Greetings to everyone attending today's public hearing held by the Panel F of the Prosecutor Vetting Commission. I am Virginia Moraro, chair of the panel, and I declare this hearing open. The Prosecutor Vetting Commission is established and exercises its powers under Law number 252, passed by the Parliament of the Republic of Moldova in 2023 on the external evaluation of judges and prosecutors and amendment of certain regulatory acts. This law establishes that the Prosecutor Vetting Commission shall undertake an ethical and financial evaluation of prosecutors mentioned in Article 3, Paragraph 1 of that law as subjects of the evaluation. The panel holding this hearing consists of 3 members and was established for the evaluation of subjects in line with Article 15 of Law number 252 on 5th of November 2025. Together with me, I have my fellow commissioners, Madam Laura Ștefan, international member of the Prosecutor Vetting Commission, and Madam Nadezhda Hriptievski, national member of the Prosecutor Vetting Commission. The subject of today's hearing is Veaceslav Potînga, prosecutor in Chișinău Prosecutor's Office, subject of evaluation under Article 3, Paragraph 1, letter E, and Paragraph 3 of Law 252 in his previous capacity as a prosecutor of the Anti-Corruption Prosecutor's Office. Mr. Potînga, greetings and welcome to today's hearing. Greetings and thank you. This hearing is being conducted pursuant to the provisions of Article 16 of the mentioned law, as well as the Commission's rules of procedure for evaluations under Law 252. During the evaluation and at today's hearing, the panel was and is supported by members of the Secretariat. The hearing is open to the public, available to public and media. It is conducted with interpretation between Romanian and English. Therefore, I would like to ask all speakers to take turns when speaking and to speak clearly and slowly to allow for accurate interpretation. At the same time, in order to ensure the transparency of the prosecutor vetting process, in line with provisions of Article 16, paragraphs 3 and 4 of the law, the hearing is audio and video recorded, and the recordings will be published on the Commission's official website within at most 3 days from today's hearing. Mr. Potînga, at the end of this hearing, you will have a possibility to come up with the closing statement, if you'd like to do so. I will start by a brief review of the evaluation process of the subject Veaceslav Potînga. The Commission started the evaluation of the subject on the 8th of May 2025 by notifying 24th of May 2024 by notifying the subject by email, asking him to fill out and submit to the Commission the declaration of assets and personal interests for the last 5 years and a questionnaire on ethical integrity. These documents are explicitly provided for in Law 252 in Article 12, paragraphs 3 and 4, and you provided the requested documents to the Commission, filled out, signed with appropriate annexes within the established timeline on 12th of June 2024. Also, in line with Article 12, paragraph 5 of Law 252, by filing declarations and questionnaire mentioned above, the subject of evaluation declares on his own responsibility for the veracity and completeness of the submitted data and consents to the processing of personal data. As a result of the random distribution of the evaluation file among the Commission panels, according to a procedure in Article 17 of the Commission's Rules of Procedure, the file of Veaceslav Potînga was assigned initially to Panel A, consisting of Christopher Lehman, Nadezhda Hriptievski, and Saskia De Vries. On 16th of August 2024, the prosecutor was informed by email about that, including about the right to declare recusal of the members under Article 10 of the Commission's Rules of Procedure. The subject did not ask for the recusal of any Commission members. On October 22nd, 2025, the subject was informed about the Commission's decision of 15th of September 2025 on the recusal of a national member Ion Graur, and the decision was approved in line with provisions of Article 17, paragraph 3 of the Commission's Rules of Procedure. Subsequently, on November 11, 2025, the subject was informed that by Commission's decision of 5 November 2025, under Article 17, paragraph 2 of the Commission's Rules of Procedure, his file was repeatedly assigned for evaluation to Panel F, given the declared self-recusal and recusal decisions approved by the commissions. So it was assigned to the panel that consists of the members that are present today's hearing. Mr. Potînga, during the evaluation, did not ask for the recusal of any member of the current structure of the panel. During the evaluation, the Commission collected information about the subject and his close persons in order to establish the subject's compliance with the ethical and financial integrity criteria as provided for in Article 11 of Law 252. The Commission obtained information from multiple sources, such as the National Integrity Authority, Ministry of Internal Affairs, State Tax Service, Prosecutor General's Office, Superior Council Prosecutors, as well as other public and private institutions, including financial institutions and open sources. The panel has also analyzed and evaluated the collected information in terms of their accuracy and relevance. So, with respect to issues or unclarities found during the evaluation in the collected information, the panel has been asking clarification questions and asked for additional information and documents. To this end, you answered 4 rounds of clarification questions that you received on November 19, 2025, December 24, 2025, 16th of January, 2026, and January 30th, 2026. You answered in due time to all of the questions, and you provided the documents that were requested. In line with the provisions of Article 16, paragraph 1 of the mentioned law, and Article 28, paragraph 3 of the Commission's Rules of Procedure, if, based on its investigation of the subject's compliance with the integrity criteria, the panel or the Commission has doubts, either the panel or the Commission will send a written notification to the subject providing all of the doubts, and will set a hearing that will take place at least 10 days after the notification to discuss them. If the subject refuses to participate in the hearing, the panel or commission will finalize the evaluation based on information that it had collected by the time without any hearing being conducted. So, on the 27th of February current year, Panel F notified the subject that it finished the evaluation and found doubts about his ethical and financial integrity, which asked to be discussed in a hearing, and invited you to take part in the hearing that was planned and organized today. Mr. Potînga confirmed receiving the hearing notice on the 2nd of March of current year, and on the same date asked the panel to hold the panel in a closed session. The panel examined the request, and under Article 16, paragraph 3 of the Law 252 and Article 28, paragraph 5 of the Commission's Rules of Procedure, decided 1. to reject the request to hold a closed hearing regarding the first issue in the hearing notice, and second thing, to accept the request to hold a closed hearing about the second subject in the hearing notice. Mr. Potînga, I'd like to reiterate that as the panel mentioned in item 16 of the decision that was sent on the 3rd of March about inexplicable wealth. In case if you, during the hearing, believe there are specific circumstances that you have to mention, but they require protection for concrete and imperative reasons that fall within Article 16, paragraph 3 of the law, you can make a request in that specific moment of discussion. In order to examine your request, the panel will listen to your arguments within a hearing, closed hearing, and after examination, and if it is justified and proportionate, the panel may decide that a certain segment of the hearing about your inexplicable wealth would be held in a closed hearing. Mr. Potînga, is the explanation of the panel clear? Yes, of course. Also, on the 11th of March, you sent the panel additional documents that are related to the topics mentioned in the hearing notice for them to be discussed today. Mr. Potînga, the documents sent by you were not examined by the panel given the limited time, but you can explain them during the hearing, and at the same time I would like to mention that the panel will examine them after the hearing in a proper working process in order to prepare the report, and if needed the panel may ask for additional information or clarifications. Before starting the discussion about the topics mentioned in the hearing notice, I would like to ask you two general questions. Do you have anything to add or correct in relation to the answers or information provided previously to the Commission or to the panel in relation to the question rounds or the documents? No. And the second question. The answers that you provided to the question rounds, as well as the information you stated in the 5-year declaration and ethical integrity questionnaire, are still correct and current as of today? Yes. I understand. Next, we will continue with discussing the topics or the issues that are mentioned in the annex to the hearing notice that you have received, and we are going to talk about issue 1, inexplicable wealth in an amount of 325,000 lei within 3 years of the evaluated period, the years 2013, 2015, and 2020. To this end, I'm going to give a floor to Madam Laura Ștefan, who is going to ask clarification questions, and subsequently any of the panel members may ask additional questions if they deem it necessary. You have a floor, Madam Ștefan. Thank you, Madam Chair. Thank you, Prosecutor, for presence. Let's start the discussion from issue number 1, indeed, suspicions regarding inexplicable wealth. And the first year where we found a negative balance is the year 2013. As mentioned in the hearing notice, the main matter in discussion is the purchase of an apartment by your ex-wife on December 2nd, 2013 in Durlești. The price mentioned in the contract is equal to the cadastral value of that apartment, and that is 325,990 Moldovan lei. We made requests towards Lara to obtain an estimate average price for real estate and white wall version in that community, and the price we were told was around 7,200 Moldovan lei for a square meter, which leads us to an amount of 463,680 Moldovan lei for the apartment in question. You also informed us that there was more investment done into the apartment, around 2,000 euro. That means 33,441 Moldovan lei for improvement. You explained that the additional payment paid to the seller derived from the fact that the repair of the apartment was simple and that it was furnished. In 2014, you donated your part of the apartment to your ex-wife on 18th of September 2014, but we find that in your 2016 asset declaration, you mentioned that address as your domicile. Looking at these things, we included in the calculation of your financial flows and your family the amount of 497,220 Moldovan lei for the purchase of this apartment, which leads from our calculation to this negative balance for the year 2013 of 139,994 lei. These are the aspects that we described in the hearing notice as well, so I invite you to comment on them if you have a different opinion than what it was mentioned by me, please. Thank you for your question. I want to be clear. The calculation relied only on the price difference, so different position about the price mentioned in the contract. After studying the documents that were provided, and the Commission looked into them as well, the Commission took as a basis only the calculation made by Lara Real Estate Company. When studying the documents that were provided, I found that the real estate company gave two different results in two cases. For an initially it provided a price of 6,956 lei per square meter, and in the second question that was asked to this company, it answered that actually the price at that stage when it was sold was between 6,700 to 7,200, with a comment that they also mentioned in their document. And they said that the price is abstract. It's calculated based on the average sales on Chișinău municipality, and for a concrete evaluation of the good, of the asset, it's necessary to evaluate that specific property and to, depending on its conditions, to see the price. In these circumstances, I believe that the price mentioned in the sale contract, the 325,000 price, is real, because according to the evaluation that I personally carried out, with the help of an expert, it confirmed that the price, the location, as Lara explained, what needed to be taken into account is location, positioning of this property in relation to infrastructure points, so because that leads to different prices. In these circumstances, according to the evaluation report that was provided to the Commission, it was found that property is in a location that is not that well developed, so that it would allow for certain facilities for a day-to-day life. It is located 2-3 kilometers away from public transportation, from the closest bus stop, and this is mentioned. Nearby this real estate, there is high voltage electric line that also decreases the value of this good, and the negative characteristic that influenced a lot is its location by a road that allows access. It is one of the few roads that allow truck transportation, and since there are traffic bumps nearby, it generates very unpleasant noise. Moreover, as I explained to the Commission, this property is a studio apartment where two walls were built from glass blocks, and another the light comes through other rooms, so there is no access to direct light in that room, and that leads to a lower price, especially since when it was sold. I moved to Chișinău. I was transferred to Chișinău in 2013, but I was looking and I was limited in money, and I accepted this property. I told the Commission that I was against this property because it did not meet the requirements that would be needed for a comfortable lifestyle. But my ex-wife insisted on it, and since money was transferred by her parents, we accepted that price and we transferred the money. But the agreements and the sale and purchase contract, the Commission could see, according to a contract, was signed by my ex-wife. I did not take part in that contract, and as a result of the registration, since it was a jointly owned property, the cadastral body registered the property in the name of both spouses. And as a result of the intervention of my parents-in-law asking for the property to be fully belonging to my wife, I filed that request for this property to be transferred to my wife, and she was left with 100% of real estate. And then I was present there only the spot. Okay, I would like to make some clarifications. The request that I made the second time to Lara related property that was specifically on that street. It wasn't a general request of prices in Chișinău Municipality. We asked for values in White Walls version property in that street, and the values we were told were between 6,700 to 7,200. If we look at that was the average value for White Walls version, not with simple repairs, but White Walls. And the amount that we reach is 463,680. If we look at 6,700, so the lower bracket of that interval, we get to 431,480 Moldovan lei. To reach the cadastral value that I think we all know that is always the lowest out of the values that could be mentioned in relation to an apartment. To do that, we should accept a 5,000 Moldovan lei per square meter price, which is much under the value that Lara mentioned. You should understand that this is why it is difficult for us to accept that the actually paid price of a purchase of a property is the one mentioned in the contract, the cadastral value. I understand you were not so much involved in that process, as you said. Indeed, there was a donation of that property on September 18th, 2014, as I mentioned before, but it shows up in your asset declaration as your domicile in 2016, even though it was held by your wife. So you are not fully separate from the existence of that property. Are there any more questions from my colleagues? I have a clarification question to what you said in answering to my colleague's question. I want to make sure that I understood correctly. The way you expressed yourself about the evaluator's explanations, I want to understand, did you ask an evaluator from the cadastral authority or from elsewhere to carry out an evaluation of a property, or is it only about the evaluation carried out by the cadastral authority generally? That is one question. And secondly, you mentioned it is a studio types apartment. Studio, but 64 square meters? Yes, to make it clear about your first question about the evaluator, I provided the Commission an independent evaluator association of independent evaluators, so they did an analysis of the location of a property. They had the cadastral plan of the property, looking at how the rooms are located, what's the access of light in this real estate, and its location. And as Lara explained in its information note, that you have to take into account the location because that influences the property. What's the date of that report? 4 February 2026. It was provided to the Commission. This is what I wanted to clarify. This is a report that was developed over many years after the date you bought the apartment. Yes, but the question was asked about it. Because the evaluation was in 2013, and as I explained to the Commission, I did not move immediately into that apartment. For a period of time, former owners lived in it because they were moving to Italy. They were going to move, and they tried to solve it at a lower price. They tried to sell some of the items in the apartment, but they could not sell everything, and you saw the receipts that we bought parts of them. And one more general question. You know very well the reality of Moldova, especially when it comes to sale prices for real estate. For a very long time in our experience, I mean generally us as a society, when the sale and purchase contract was stipulating the price equal to the cadastral value. That does not necessarily mean that the real value of a property that is being sold equals the cadastral value. The cadastral value is established for taxation purposes, and that process that was not so efficient was proved by the latest changes and by a re-evaluation of real estate by the cadastral. This is a process very well known in the society. I think over the last months this has been a big topic for discussion. Still, at the date of sale and purchase of the apartment, even though the money came from your parents-in-law, the price mentioned in the contract as being equal to the cadastral value, was it the real price for that property, except the fact that it was 2 kilometers away from public transportation and so on? Because the area where it is located is considered not a simple one, and it is deemed to be quite favorable. I mean, generally, this suburb of Chișinău. I think we're talking about different regions. As I explained, the house is close to Tudor Vladimirescu Street, which is one of the main road for transport. But what is specific for that street is that it allows trucks to drive, and an empty truck, when they go over a speed bump, you can hear it even if you are inside the apartment. Moreover, across the street from this real estate, there is a firefighter station, which is, again, not exactly comfortable when they are moving towards calls, and most likely it is 2 meters away from the main road. It's not an area for children, let's say, no playground. And generally, air pollution in terms of exhaust gas and dust going up from the street, because if you left the windows open, you could gather a little bucket of sand after it. Okay, thank you. I don't have any more questions. I want to clarify once more. The request we made to Lara is about that specific street. We did not ask for general values. I understand, but you should understand as well that there is a question mark when the value mentioned in the contract is the cadastral value. Because we know what was the practice for years and years with the cadastral value. I understood, I made reference to that Lara's document, whereby it confirmed that for a correct evaluation they should see the property and express their position about, given all the criteria. I think that's a standard comment in all of the information that Lara provides to us. Let's move to the next year, if you agree. That is year 2015, where we found a negative balance again. It's smaller, minus 9,475 Moldovan lei. It comes from you buying a car, Mercedes-Benz. If I understand correctly, it was purchased, but based on a proxy. So the actual transfer of property, yes, that car was brought into Moldova by another person with Lithuanian number plates. It wasn't subject to customs clearance, and in that year they passed the law on registration of means of transport and receiving or collecting the customs duties related to that. I used that situation and I purchased that means of transport. It was already being used by me, and the documents that I provided to the Commission shows that it was imported by another person he's a neighbor of mine, and I bought it from him. The price was mentioned in the contract. And to explain it clearly, you declared a price of around 2,000 euros. We analyzed the data from the customs service, where the value of a car is estimated at the year of 2015 as 60,000 Moldovan lei. That means around 3,000 euros. plus the duties, 23,470 lei. But duties were paid in 2017, so we don't take them into account for the year 2015. However, the value of 60,000 Moldovan lei has to be taken into account for the year 2015. And mainly from adding this value to your financial flows, we get a negative balance of 9,475 Moldovan lei. So the discussion is about, again, price difference between the price you declared as a contract price, 2,000 euros, for which we have nothing else but your statement, and the value that was established by the customs service as around 3,000 euros, which means 60,000 Moldovan lei. Would you like to comment on this? To be closer to the topic. In the first year of my work, I was in the customs service, and the procedure of customs clearance for vehicles or any property that is being imported to Moldova goes through 6 evaluation methods of establishing the customs value. And if there are no circumstances or papers that would confirm expenses or other properties, as it is done currently, the customs uses the 6th method of evaluation, meaning that they have a nomenclature that was developed by the customs service, and they have estimated prices of goods for certain types of goods. So the customs officer does not evaluate the property itself, looks if an item fits into a certain category of goods. So there was an order from the customs service that provides for a regulation. In my practice, I had access to it. I know what was in it. And for the Commission, I only retrieved Chapter 11 of the regulation that stipulates the means of transport imported to Moldova, regardless of duties or regardless of the sales and purchase contract, will be evaluated according to the tentative prices that are included in that nomenclature. Moreover, based on it, it's not the duties to be paid to the state that are calculated, but it's not the tax, but the customs duties are calculated, because that goes to the budget of the customs service. And of course, to make it better for their budget, they will take the most reasonable price for them. So the difference was not large, to 300 lei that was added to the cost of import duties. That did not disturb me. I did not insist on it.
But the transfer of the 2,000 euros, as you said, was that done cash or by wire transfer to your neighbors? That was cash. And are there, well, is there any receipt whatsoever, any written document whatsoever? Well, sorry for cutting you off, but that person is away right now, is not in Moldova, that person. I understand. But this means that, well, it means that, yes, I do not have something to confirm it. There was a contract, because it is in the customs service. In their case file, I took some measures to find that document with the Public Services Agency. When I reached out to them, they stated that that documentation was already destroyed. The customs service said they no longer hold that documentation, so understood. A couple of clarification questions, if I may, with regards to that that vehicle. The first one, you mentioned that you purchased the car from your neighbor. Was there any preliminary agreement before it was imported into Moldova to have that car brought over for you specifically, or did he import it for their own purposes and then they decided they don't like it, they don't want it, and for other reasons they decided to sell it? Well, that person, they had a lifestyle. They were importing cars and selling them. That's what they were doing. And that car was brought to be sold on the domestic market. And having seen the condition it was in, having analyzed the circumstances surrounding that asset, I decided to buy it because it was very cheap. The price was really affordable, given that we were neighbors. He did not add anything on for that car. He's just established that 2,000 euro price. And that also included bringing it over to Moldova. So if I got it right, your neighbor had no profit whatsoever out of that transaction. That what was the reason for him to even engage in this transaction? From your point of view, why would your neighbors have done that? Well, because we were merely neighbors out of neighborly feeling. And you stated you knew what the procedures were, the customs ones, for the duties, import duties, and the customs value of assets for cars. There is a practice that we are also familiar with, given the provisions of the regulatory documentation governing imports. So there are methods that are being applied to calculate the value at the customs of the assets. And you've also mentioned that there was in the customs file and in the Public Services Agency file, there was a contract, if I got it right, on the procurement of the asset abroad. Is that right? Or was it the contract between you and that was a sales and purchase agreement between myself and the owner of the car abroad? So the last name was something more complicated, Knaunas or something like that. So the sale and purchase, per se, from a legal point of view, that was a transaction via the intermediary, my neighbor. I signed the contract, that agreement. But he signed an agreement with that person abroad. That was a requirement of the customs service at that time when it came to be able to collect, for them to collect the import duty. So there was a power of attorney for your neighbor to take action abroad, to take action with the customs service, and the documentation was already then filled out by you. No, the documentation was taken care of abroad. There was a model sales and purchase agreement. The owner, registered in Lithuania, put the signature down and indicated what the price was. And then I was given the contract and I signed it. What was the price? It was 2,000 euros. That's what it said. 2,000 euros, which included 1,500 the car and 500 the transportation cost. The final cost was 2,000 euros. And just for out of neighborly relations, I mean, he often travels in that way. And when this car was brought in, did he bring in other cars on that date or on other dates in the vicinity of that particular day? I am not aware of that. I just knew this was part of his lifestyle. He often traveled to Lithuania, Germany, Poland. Twice a month he is away. And this work of importing cars, out of what you are telling us, that he was traveling often and bringing over cars into Moldova, was that his main bread-earning activity, or did he have other activity as well? I cannot know with certainty. I don't know very well. I just know that he's been traveling abroad and coming back to Moldova. Thank you. No more questions from me regarding this matter. Over to you. I would just like to understand. You bought the car in 2015 or 2017. When was it? Well, de facto, it was purchased. I mean, there was the agreement, and the car was passed over in 2015, if I'm not mistaken, because that's when I started paying the duties for this car. And I think I've annexed something that I've paid the road tax for foreign cars. And out of that, I can see that initially it was brought in by that person, and afterwards I took over the baton, and then I was in care of this asset. It was actually purchased in 2015, but all the sales and purchase transaction and formalities and registration in my name was 2017, when the law on the possibility to register such cars entered into force. So if it wasn't for the amendment of the law, that you would have continued to drive that using that power of attorney and not the sales and purchase agreement. Well, for as long as the government allowed it, I would have done it like that. Otherwise, the car would have gone back away from Moldova. What was the reasoning for you not have bought it initially? I mean, you were a prosecutor. I think, well, I might have not been clear enough. It was purchased immediately, but the car is an old car, let me put it like that, very old. It was much older than what is allowed to be imported into Moldova. When the government passed a law that allowed within a short period of time for cars that came in until a particular benchmark where they allowed those cars to be registered in Moldova. And that car was in that category. And then it was formally registered in Moldova when that became possible. Are you aware of the average price for such cars? You mean those that are registered in Moldova or abroad? That are registered abroad. That was about 2,000, 2,500 euros, not more, depending on the trim, depending on the condition the car was in. So you did not buy it for a cheaper price, turns out. Well, earlier, or it's either that I misunderstood, you said that you bought it because it was very cheap. Well, 2,000 was reasonable price that allowed me to, well, use it without incurring big expenses. So you could have bought for that same price from somebody else, not necessarily from your neighbor. Well, I said that there could have been 2,000 or 2,500 euros, so it was that range. All right, thank you. No more questions. I have something to ask regarding this matter. Did you have now, considering how old the car was, so to speak, did you incur any expenses to fix it, to change some parts, replace some parts in that car, and how much was spent for this, for fixing it and for spare parts? In the rounds of Q&A, as I said, there were some common ordinary expenses like related to oil, and then some other minor parts, nothing substantial. Initially, I was not going to invest into it, really, because I knew that if the law was going to be amended, then it would have to be taken out of Moldova. There was no point in fixing it. But after it was registered, I had to go through another technical test, and then I've changed certain details, certain parts. Thank you. I don't have any other questions regarding this matter. Thank you. No more questions from me as well. So I suggest we move on to the negative balance for 2020, that is 176,319 Moldovan lei. And the key point about it is with regards to the procurement of a house with an area of 101 square meters and an adjacent plot of land in the town of Cricova. Let me go through a brief review of this, of the key highlights regarding this house to make sure that we are all on the same wavelength and have clarity regarding the matter. And I would like to address what the situation of the house was before you became owner in 2020. So in 2010, the first owner of the land has registered it with a cadastre. In 2012, in the cadastre, the house was registered, 101 square meters. In 2013, this house and the adjacent land were sold for 1,600,000 Moldovan lei. And that same year, in that same year, on the 2nd January 2013, the buyer took a loan to purchase that house. Now, given that mortgage, an assessment of the house was carried out, and the value of the mortgaged asset was established at 2,198,000 Moldovan lei. That is almost 2,200,000 Moldovan lei. And in exchange for that mortgage, the buyer was going to get a loan of 1,600,000 lei, Moldovan lei. Now, this buyer owns the house until 2015, and in that year, an agreement is entered into for the voluntary execution enforcement of the mortgage right, and the bank becomes then the owner of that asset. And the bank then owns it from 2015, April 2020. In 2020, there is an enforcement regarding this asset, and for the enforcement, there are two people participating, and it's just in the middle of a COVID crisis. The 7th of April 2020, to be more precise, so this is when this enforcement procedure goes down, and it ends with the procurement of that asset by one of the two participants. And the value of that is 762,412 Moldovan lei. Afterwards, the buyer, the one who bought it at the end of the procurement, sells it on the 7th of August 2020, sells it to you for the price that is under the one paid by the buyer for that same asset at the auction. There are several issues we'd like to raise with you as far as this asset is concerned. I would just like to say that as regards the enforcement and the auction, there were only 2 participants. One of the participants has appealed against that procedure in late 2019. However, afterwards, they continued to be part of that process that ultimately ends with the procurement of that asset by our share. And the auction is organized by Nicolae Pasha, the bailiff Nicolae Pasha. Now, to get started on the discussion, I'd like to ask you if you knew the seller of the house. Did you know who that person was? What was the relationship between you and the person who sold the house to you for a price cheaper than what he paid to acquire it, only 4 months away after having bought it as part of the enforcement procedure? Well, I thought I provided details in the Q&A sessions. I did not know the seller. I'm not in touch with that person. If I had his contacts, I would have gotten in touch with him regarding the matter, specifically about the price for the sale and purchase. Now, as to how I got to meet that person, I told the Commission that after they bought the house, they performed the assessment, they decided to sell it. And this was told about to a friend of mine who is into real estate. He's a real estate agent. He was working in that field. I told the Commission that the real estate agent, that I've known him from his previous work. And he knew that I was on the lookout for an apartment. And during the rounds of questions and answers, you might have noticed that after the 2018 divorce, I moved elsewhere to live. And from 2018 to 2020, 2021 to be more precise, I've lived elsewhere. I was looking for a place to stay that was affordable. So 3-4 years I've been looking for a place. That asset was subject to an assessment performed by a real estate broker. We'll get to that point as well. We'll get there as well. So apologies, but just a clarification question. Did you say that after the divorce until 2020, and then you said 2021, you've lived elsewhere until 2020? Or was it until 2021? Until 2021, I've lived elsewhere. Have you any idea as to when that person, when he got in touch with your friend, the real estate agent? And what is the context of that discussion? Do you know that? Well, I couldn't be able to say with precision, but more or less around that same period. The asset was assessed at their request. An assessment was performed, looking into other assets that were being sold in that region. Well, they've looked into whether they can sell it and taking into account the fees, the broker fees, and so on and so forth. And out of that discussion with that person, I knew that the person wanted to sell it as a matter of emergency for some personal needs. But when was that happening? So, they became the asset of this. I can't tell with precision, but that was very close to when that asset was sold, at least. Well, a month or 2 months at most before the sales and purchase transaction has gone down. So June, July perhaps is the best time that I can think of. Have you any idea of how they got in touch, of how that even happened? I would like to remind you, this is 2020, and there were restrictions on moving around. So did they know each other? Did they get the number from our website? No. The real estate agency involved there is a renowned one. So that person might have gone to different agencies and has come to this agent that I knew. And that person assessed the asset, gave their opinion, and then did not further engage with the sale of the asset. What about the price negotiation? It was direct because I had gotten the phone number of that person. I got in touch with them. I went down there. So you talk to you talk to that person, to the seller, the owner of the house, yes, the owner of the property. But the contact person, the real estate agent, that was someone who just passed the data, the contact data to me, and told me that the person was looking for someone to sell to as a matter of emergency. When we were given the keys to the house, the keys to the house, well, was not even locked, so to speak. Out of the pictures that I've shared with the commission, you saw that the gate was in a very poor condition. In the yard, there was like a very little forest of trees having grown really big. And I think somebody broke into that house because nobody was living there. So it looks like somebody broke into it. So we just had an understanding, an agreement. I've initially, well, he needed a guarantee that I was going to buy it. And I gave him the first installment as set out in the agreement, a bit more than 120,000. He signed something like a commitment with me. And then I started working towards the paperwork for getting a loan. So more specific about the dates. In August already, I started inquiries to get a loan. You've mentioned assessments. That asset was assessed and then overvalued, I should say, and the amount seems to have been overstated. There's an assessment on the 16th of January 2020 that is under a procedure whereby Rș became the owner of the asset. And then the 16th of January 2020, as I said, and the value is established at about 1,050,000 Moldovan lei. And then the enforcement procedure, the auction, the price paid. And then there's another assessment in order to get a loan. And the market value of the asset, considering the 27th of July 2020, that's 983,000 Moldovan lei. So there is an increase, or actually a downward valuation by about 60,000-70,000 Moldovan lei. But an increase in the value of the asset compared to the price paid during the enforcement procedure, that difference is about 200,000 Moldovan lei. Which is why I am asking you, what action did you undertake until that asset was reassessed by the bank on the 27th of July 2020 via expert group consulting? When I visited that asset, well, I showed that to the commission that the condition was not quite good to be sold. So before the expert came over, we cleared some part of the yard. And that was before the assessment, the repeated assessment. So you did that on your own, or did you pay someone to do it? I did that on my own, together with some other acquaintances that I had. Somebody came over inside the yard and they took away something that was not supposed to be there, and that is more or less, well, before the evaluation, before that asset evaluation. And that was actually a condition imposed by the bank. The bank said if this property is not evaluated and established a value that is, well, as I was saying, the bank was going to accept giving a loan out only if 70% of the total amount of the asset is indicated. So if it was 983,000, the amount that was given to me was by, well, as much as the bank was going to guarantee to take on. And actually, there was also the loan-related documentation. The bank performed a study before it agreed on giving that loan out. And there was something, I think, a word, the provision stated that if I had 470 points as a score, and then the loan was agreed upon. But if there was a smaller prize, if I had gotten a 400 points as a score, they use this sort of a scale, then they might have rejected my application for a loan. So you practically had access to that property even before actually after I paid the first installment. And you made that payment when? Before the contracts were entered into. When was that? Before the assessment, but because in those circumstances the person agreed with selling me that. I was supposed to pay the first installment 10%, 120,000 lei, and then the latter granted their accept regarding me getting into the yard even, and then I took care of the loan. So you paid in early July 2020, shall we say that? Or rather in late July, I'd say. So late July, that's when the assessment is finished. Well then, but before the assessment, so the 27th of July 2020, that is when, that's the date on the assessment report, because an assessment takes time. I mean, you did some clearance work and cleaning in the yard, but the report was in the name of the former owner. Either way, it does take some time for the experts to perform that assessment. I can't tell. I think it took about a week. And then another week for you to perform some minor improvements. That was before the assessment of the asset. Because otherwise, we needed a price that was competitive. There had to be a competitive price given the loan. I agree with that, but I'm asking you when that happened. I mean, I can't be very precise about the dates, but you did that work on your own, did you not? Yes, I took care of that on my own, and that happened before the assessment. The evaluator, the expert said, look, on Saturday, I will come over for the assessment of the asset. So I did my best to do the minor improvements by the date that the experts said they would be visiting the house on. So that's July, late of July. Well, late of July, that's the assessment report. But it didn't take that long. Well, a week. And then it took you about a week to make minor improvements, to make it more presentable, so to speak. Well, then as for the people who worked with you, those acquaintances, did you pay for them for that? That was family, relatives. Okay, did you pay them? I did not. Okay, anything you'd like to say? No. Just one little thing, a remark. I'd like to kindly request that you take turns to speak because there are interpreters trying to keep in the same pace with you. Thank you. Thank you, and apologies for the momentum sometimes at the heat of the discussion. Now, Prosecutor, sir, a question about this firm, GoFarma Consulting, that performed the assessment on the 16th of January 2020. So that is the company that said that the value of the house was 1,050,000 Moldovan lei. Did you know that firm, that company? Did you have any professional engagement with it? I understand where the doubts came from. We tried to be as transparent as possible to make sure that you know what this is about. The file, the enforcement one that you've mentioned, that you, in the context of which you mentioned Mr. Pasha, and I did not know about it, or that GoFarma Consulting was part of that case file that was the evaluator there. These circumstances became known to me out of the information shared by the Commission. And I realized that out of the questions from the Commission, I realized that that case was involved in a criminal case that I handled. And even now, it's still pending. There is no final decision yet. There is a colleague in the central office taking care of it now, handling it now. Now, what the questions are, though, with regards to the following, because we see some sort of a pattern. Well, we see a particular way of conduct from the assessor in relation to some bailiffs, such as, well, thinking of the case that you've handled. That case was with you between the 23rd of July 2019 until the 27th of February 2020. And on the 27th of February 2020, you issued an order to write off the case. Now, regarding Botsan and GOFMA Consulting, and GOFMA Consulting on the 16th of January 2020 has drafted this property appraisal report, and the value was set down there, a value that you will buy it for within less than a year. So there's temporary, this overlapping in terms of time, and the modus operandi that we see in the case that you've handled. And that, exactly as with the case that we've talked about earlier, with regards to which we have some question marks, some questions, well, that implies a property appraisal performed by that appraiser company, and then there is enforcement by a bailiff, and then your order was invalidated by the court, and that was explained in the notice of hearing, in short, as to the aspects that were raised and further detailed on by the court. I have to admit that for me it is a little bit awkward to see the same company under investigation by you, and that company is performing the appraisal of a house that you end up buying afterwards, and from one who is concerned in an enforcement procedure. As I previously explained, about the existence of this company and its involvement with the sale of the house, I've only found out about it from the Commission. Until that moment, I had no access. I've been in touch with the individual, the natural person, but I did not have any contact with the company, specifically with this appraisal company. I mean, there's so many appraisal companies. GOFMA Consulting, for instance, there was a time there was many issues with it because it's a large company. It's not a small one, and it has a lot of appraisal experts. But it was not purposeful. It was not done with intention, specifically with intent. And if I had any link with that company, then I think the further appraisals would have also been performed by GOFMA Consulting. But as you've seen, the property appraisal report at the request of the bank, that was performed by a different property appraisal company that delivered their opinion on the asset. So you are saying there is no link between the fact that you issued an order to dismiss the case on the 27th of February 2020, after on the 16th of January 2020, GOFMA Consulting issues this property appraisal report that allows for that asset to be bought for 760,000 Moldovan lei. You're saying there's no connection between this. It's a coincidence, and what is more, if you look at when the criminal case was initiated, that was in 2018, long before, I think it was 2019 that it reached you, the 23rd of July, 2019. I mean, that's when you have gotten it. The criminal case was initiated by the Central Office, the criminal investigation body of the Central Office of the Prosecution Service. So for 1 year it was not being handled by me. And then the General Prosecutor sent it over to the Central Office of the Prosecution Office. And then when it comes to access to the enforcement case regarding that particular property, I had no access to that. But the person who denounced the actions of the bailiffs, well, he was not happy with how the asset was being sold, because that was seized by the bank, and they were not happy about it. But I told the Commission that the foundation for that enforcement decision, well, the basis for that was not the arbitrariness of bailiffs, but actions that were explicitly detailed in the writ of enforcement. Evacuate people, sell the property to a bank, Invest Privat Bank, if I'm not mistaken. So a similar request with the one filed by the other participant in the enforcement procedure regarding the asset that you ended up buying at the end of the day in 2020.
Do you know about Article 131 of the Enforcement Code? It provides for nullity for the purchase of property from subjects under enforcement procedures, and that includes prosecutors and vet lists. So could you please provide a reasonable explanation for the decision issued by Mr. R.Sh. to sell you a good that he had only purchased at a price that was lower than the purchase price only 4 months after the purchase? You know, I cannot give you an explanation about why he sold it like that, but I could just admit that the person borrowed that money to purchase the property, and based on the documents that were provided by the Commission, he had worked in the banking sector, and I think he may have had a credit that he had to repay as a matter of urgency, but there was no prior interaction between him and me. I want to clarify, we tried to get in touch with Mr. R.Sh. Our attempts were unsuccessful. Letters came back unanswered. So that's why I'm trying to understand, with your help, why would someone purchase a property in April to sell it in August at a price that is lower than what we paid in April? I remember the period of a pandemic, COVID, especially its beginning, when everything was uncertain, and it seems this economic behavior seems difficult to understand. Just in the middle of the restrictions, when we were not allowed to leave home, then under specific conditions, Mr. Rishi takes part in an auction, purchases a property. Let's leave aside the resources. Let's suppose that he had some resources, and then he sells it again, and then we are in the he buys it in the middle of the restrictions, and 4 months later he sells it at a price lower in a period that was very stressful for us all. For me personally, it is really hard to understand this economic behavior. That's why I'm asking you, do you see any explanation? As I believe that this person purchased this property when it was assessed, because I understood from the real estate broker that he wanted to sell, and I think he obtained an evaluation of real estate, and he understood that it will cost a lot to renovate it, because when I got this property and I started some repairs, I saw some hidden defects that would have decreased the price. Still, as a preliminary and superficial intervention, you just cut the trees in the yard, you clean a little on the inside, and the value is going up to 100,000 lei compared to what he paid. Well, speaking about the evaluation that the expert for the bank did, you may have noticed in the evaluation report, the evaluator provided 3 prices. Market price, which is the best and most favorable price to pay for that property in circumstances where the seller gets the biggest benefit. That is 93. Then the liquidation price, that is the price for selling the property if minimum investment, minimum marketing is done in a reasonable time, as in circumstances that I bid. And recovery price, if it is destroyed, how much it will cost to recover it. And all these 3 prices are different. For the Commission, you see, the liquidation price that was included by the expert is within the boundary of what I paid for it, with slightly more than that. Moreover, from what I've seen, the Commission again requested Lara, and it confirmed that the reasonable price for that house, well, in that region, was around 6,500 lei, or 7,000 lei for square meter. And if we look at the highest price set by Lara, we have a price that is almost equal. It's 770,000 for this real estate with 3 acres of land and 110 square meters. If that property was quite degraded, how did you manage to move in 2021? That was 1 year later. You know, we will have a discussion about the amount you spent for repairs, and maybe we can park this question for that moment. One clarification, please. Could you please tell us precisely? 1 year later, it means 12 months? Or, I mean, when exactly did you move into that house? That is the period that I declared to the Commission. November, December 2021. I answered that in the question round. So until that time, certain works were carried out. To clarify, the works were carried out to give a possibility for me to move into the property. Well, some things were not done yet for the housing. So we opened the discussion about repairs. A question. You say that you moved in November, December 2021. How much did you invest before November, December 2021? We had this long correspondence trying to understand how exactly those repairs expenses were split. In the end, we divided them clearly, equally per year, around 2,000 euros per year starting in 2020. But since you're saying that the property was in a deplorable state and you had to invest before you moved in, I'm just thinking, was that distribution or division correct, or should we put more significant amounts in the beginning of a period before you moved in? I made a distribution. I suggested to the Commission. I said that currently I am still repairing, but it is slower because my financial resources do not allow for it to be faster. But I told the Commission that initially first works were done. The heating system was replaced, and the heated flooring was installed in the house. How much did that cost in 2020 and 2021? I would be explicit. I'm asking you once more. Think a little. You moved in November, December 2021 into the house because in the question round you gave us a different. Then I'm mistaken. Think a little. Take some time and think. When exactly did you move? Maybe you made a mistake when you answered back then, so that's also a possibility. As I mentioned in the first question round, oh, then it's November 2022. So you did some repairs for 2 years. These repairs, as I said, all these repairs were done in 2022, 2023, but mainly you said that the major things, the piping, the flooring, 2020, 2021, sorry, it's hard to distinguish what two people speak at the same time. I have some clarification questions, Mr. Potînga, as well, regarding the price of purchase, the price at which the former owner R.H. bought it. The difference between the purchase prices by the former owner and the purchase price that you paid was 3,000 lei based on the contract. So that is, in my opinion, the difference. That's not enough even for notary expenses and fees to be paid to the notary. So what was the reason of the seller to sell it 3,000 lei cheaper? I would understand if it were like 3,000 euros cheaper, but 3,000 lei, maybe. How can you explain the small amount? I think that is because of the currency exchange rate, because the understanding was in foreign currency, so the first installment I paid in foreign currency, and I saw it only from the Commission. I did not pay attention to the amount. I understand it. Thank you. Could you please tell us exactly the period, if not the approximate date? In how many installments, in what currency did you pay the price for the real estate? It wasn't in installments. It was paid in one amount. It was given around July 2020, before the evaluation of a property, because I needed to do some cleaning in that property. So this is what you said. But you paid in different currency. But it wasn't only one currency, or two or three. There were dollars and euros. Could you please tell us precisely the amount? No, I can't, because I did not keep strict records of that. It was an understanding. I gave it to an exchange rate that was beneficial for him. I told him I have this amount of money, and the remainder will be transferred by wire through the bank. So we're not talking about 2,000-3,000 lei that were here and there. We're talking about amounts that are more significant in foreign currency. Don't you truly remember? No, because it was also in lei, in euros, in dollars. But approximately the amounts, don't remember? No. Few more questions to clarify. Could we talk about the repairs expenses that you had? If I may, I want to clarify one thing for the Commission to have clarity about results after the transactions with the bank. So the final installments, when this will be paid by 2043, this property will cost me 1.2 million. So I would not be open to pay cash amount to that person when it's not sure that I will be able to keep paying for this property. And if we include a price for repairs, this price gets to the initial price of evaluation at the first round of repairs and sale. If possible, I would like to go back to the buyer, the one who took part in the auction of 7th of April 2020, with his initials, Arsh. How did you find this seller? Could you please explain? The data of this buyer were provided by a friend of mine who used to work in the police, worked together with me before. After that, he left police and started to be a real estate broker. Where did he handle it? That person approached him with a purpose to conclude a contract to sell that property, to do that quickly. That was what this real estate broker told me. So do you want to say that not the broker didn't gain anything? So the realtor, he didn't get anything, not the guy who took part in the auction. He took the risk going there during the emergency period, and they somehow made a gift for you to get this price to get this house at a very advantageous price. No, the idea is that the realtor went to that property. He evaluated the property, told the person the price he could get in the circumstances where they couldn't find common ground, because, as the real estate broker told me, if we add the tax to be paid, or the fees to be paid for cleaning all that property, to bring it to a condition to be able to raise its price and to add the expenses of a real estate agency, that person wouldn't be able to sell that property within the time frame that he needed to do that. And for that reason, no contract was concluded with them, and I saw it in the answer of the real estate broker, who said that the person disagreed and he left. Do I understand correctly? You say you have no connection and you can't find that buyer? No direct connection with him. No connection. But earlier you said you got his phone number and you communicated. That was in 2020. I don't have that phone number anymore. And this friend of yours doesn't have it either? No, he doesn't, and I saw it in his answer. He said that he does not have a contact detail of that person, but he's a real estate, and you see he has hundreds of telephone numbers per day that he talks to and visiting properties with. Did he sell so many houses in Cricova? I'm telling you the truth. It's really hard for me to understand that you can't find a person who sold a house to whom you transferred, the bank transferred money to, and this person is not to be found in the year 2026. And this is a 5-year period, 6. From a legal point of view, that is possible, but investigation actions would have to be done, but he's not a subject to a criminal proceeding. I'm not speaking about you as a prosecutor, I'm speaking about you as a buyer of that house. A very reasonable time has passed, and I don't have his contact details. Phone changed, phone numbers was left, and I have not even the real estate broker has the contact data. Thank you. No more questions. I'm sorry to insist, but you purchased a house that is located on a land plot. This house has a heating system, electricity system. Let's say the electricity system burns out. You bought it from someone else. You should know where these wires go through. It's kind of complicated to accept that 6 years later you don't have a phone number of the one who sold you a house, because we don't buy houses every day. We buy it maybe a few times if we are lucky. Most of us don't even get to do it once and rent their places. So you stick to the same position. There is no way that you could help us contact that person. 100%. I don't have access to his data. I don't know anything. The only information was obtained by the commission, like his salary, from where he got it, and the activities that he had. But this person did not know about the wires because he purchased the house from other people. But why would he have done that? Buy the house to sell it immediately? Because that's the question. I expressed my position previously. What could happen? It would be interesting for the person who buys a house to find out where through electric wires go, if he bought it for himself. He couldn't do that because the bank was selling it. Yeah, but the bank probably had some documents from the previous owners, and it's the bank's interest to have some goods that they can obtain value from. The bank only had cadastral documents that allowed the evaluation of a property and putting it up for sale. So the bank could not provide that gentleman with any contact detail about the former owners? No. All right, can we move to the questions about repairs? One question only about the reasonable nature about buying and selling in a short period of time. You mentioned that the seller, in the discussion with the real estate agent, wanted to sell it as fast as possible, and if I understand it correctly from your answer, the thing that the real estate agent mentioned that it wasn't possible to sell it very fastly, he gave up on the services of that real estate agent. Do I understand it correctly? Yes, the person wanted to sell that real estate very quickly, and the real estate agent told him that it was necessary to bring that property in shape before selling it, and that requires investment, especially if you sell it through an agency. Especially, we all know, if you sell it through a real estate agency, every agency adds their commission included in the price. And the person decided that it is not reasonable. Still, do you know about any of the circumstances or situations that made the seller to decide on selling the property a little bit smaller, if we calculate those 3,000 a day, but we can ignore that. So to sell it at the same price that he bought, what was the reason? How was that transaction reasonable? To buy it and in a very short time to sell it. Were there any circumstances that maybe you know about from the seller? I told you I don't know about any circumstances, but the seller was not going to tell me about that. Needing to sell the property urgently decreases the price, and the buyers are looking for something that is reasonable for them and the price that would be good. So the only thing that I can think about is maybe he had some debts that, and he was selling the house to cover those debts urgently. One more question. But maybe I'll go back to that. Let's move to the other expenses because we have more questions there. We communicated with you about expenses for repairs and improvements in your house. And after our today's discussion, I think we need to go back to that because you say you moved in November 2022, or was it November 2021? It's the one that it's November 2022, yes. November 2022. The main effort for upgrading repairs took place in 2020, 2021, before you moved in. We made the calculations. We somehow uniformly divided it around 40,000 lei every year. Convention said they had no more doubts about that repairs. So you are okay with that distribution? As long as it doesn't affect me, I think I agree. But I told you, but it does affect you, because we are talking about 2020, where you had a negative balance of 176,318 lei, and that includes both the purchase that weighs most in this calculation and the repair expenses that are allocated for that year, around 40,000 lei. 40,300 lei. I believe that I was clear enough that the price explained to me and paid by me, because I paid for the house 120,000 plus the installments that have to be paid during the credit period. By now, I paid 120,000 that were paid in cash. That's part of the contract, and the rates I pay every month for the credit. All the other money was transferred by the bank into the account in the account of the person from whom I bought it. In the end, as I explained to the Commission, in 2043, I will have paid a bit more than 1.2 million lei. And I tried to convince the Commission that the price paid by me is a real one, because it is included in the contract and it has perspective. Are there any more questions? I have a few more questions. When you found out about this property being available for sale, as any by you, to say it colloquially, did you do some investigation of your own to understand that there is no debt or other difficulties that could hamper your transactioning later? Well, investigation, some minimum. I talked to the neighbors. Neighbors from the real estate you purchased? Yes, one of the neighbors, because I got in touch with him. I found out from him that it was sold by the bank, who lived there before, some useful initial information. And then the bank handled all other investigation, because the bank wouldn't give a loan for a property which has some doubts or some encumberment from other. Did you have access to that information from the bank? No, they didn't provide you. The bank only asked for documents from the seller about the way they acquired that property, and they got the auction process. And then the bank carried out the investigations. From me, they only asked to provide for an evaluation. Now, I have a few clarification questions about the repairs or the renovation works for that real estate. You mentioned it was in a deplorable state and it needed various types of works in order to be able to move in and live with a family in that real estate, including some refurbishing outside what you did before you evaluated the property. If I understood that correctly, you cut down some trees, or I don't know what the wording would be. So you also installed heated flooring in the house. Could you tell us, as precisely as you remember, in the year you purchased the apartment, this house, what works precisely were done with you, not only by you individually, because I believe that you did some of it yourself, but by professionals or constructors or whoever handled the repairs or improvement works? And approximately what costs did those works imply? I mean, you needed, say, to change the doors or the windows, you needed to build a staircase between the floors. What happened in the year you purchased the house and in the following years until you moved in? We go back again to that delimitation that I previously provided in the question round, where I said that the stringent needs for repairs were to get the heating and the flooring. From the first pictures that I provided to the Commission, the floor was made of tiles, and having a small child, that's not good for him, and those were the first works to be done. The heating system, and I think pictures were provided. The pipings were changed and heated floor was installed, and then they covered the floor with a mixture. These were the first ones. So this means that you took away the tiles from the floor, you took it away from the real estate. You installed the heating, which means you put piping or whatever it is called, this entire system. You needed a new connection to the centralized heating system, or did you have your own heating system, heating boiler? But since the boiler was stayed unsupervised for a long time, it was. So did you replace the boiler or not? No, I did not. The boiler stayed. It was only adapted because certain parts of it were taken away, but the house is connected. The heating was done through electricity, the boiler that you mean. Some certain details were added to it, which was taken away before. And the rest of the heating system was through a furnace. Going back to heated flooring, you needed to install some additional pipes for the heating. Then you need to fill the floor. Then you need to put new tiles. So you kept the old tiles? No, this was one of the documents that I kept and could be identified. I put laminated flooring. So I'm not the biggest specialist in constructions, but from what I understand, for heated floors, you can't have laminated flooring or wooden floors. You put tiles because it's better heat conductor. No, it's laminated wood flooring. They are you stick them on the floor. You can't take them away, meaning. Well, what were the approximate prices? I can only tell you the final prices by the time. The total price was 280,000 lei altogether for all the works. By the time when I filed the questionnaire for the Commission for the year 2000, for the year 2023. Well, it continues today, but what is being done is minimum. You saw the pictures on the surface. The house stayed the same. The gate was replaced. You saw the beginning and the pictures in the beginning. The gate used to be wooden and it was broken, so the gate was replaced and some cleaning around was done. Still, can you tell us, when you moved in with a minor child, as you mentioned, it is difficult to believe that some repairs are happening in the presence of a child. What kind of works were done, if any? And what were the amounts? How much did they cost? After you moved in, I'm speaking about interior works. I understand that on the outside you didn't quite do anything.
As for some finishing renovations indoors regarding these works, from my point of view, I've explained it. To me, the renovations, the finishings, as the Commission asked about it. So the circumstances, well, in this regard, regarding the circumstances in 2023, there was some indoor works, as in buying some appliances. So that was some additional expenses, right? And so that the Commission trusts what I say out of the receipts that I submitted from the company that installed the laminate flooring. In 2023, they've installed, because that's when I paid the last installment to them, they've installed some of the baseboards inside the house, and that can be performed with us inside the home. Thank you. No other questions regarding this aspect. Looking at my colleagues. If there aren't any more questions regarding the first matter, we can move on to the next one, the next issue in the notice of the hearing. And as announced in the beginning of this hearing, and as you were informed about it, about the decision of the Commission regarding this, this is going to be heard in a closed meeting. Everybody in the room is asked to leave. Now, these were the questions we wanted to clarify today in the hearing. Let me look at my colleagues if there's anything else they would like to raise. If not, then here we are at the end of the hearing. If there's anything you'd like to say as a closing statement, then you have the floor. I will be very brief. Thank you for the possibility to provide answers to the queries of the Commission. I hope I was very convincing regarding my explanations to the doubts that were raised, and I hope that it'll be a positive outcome ultimately. Thank you for participating in the assessment, Prosecutor. Sir, thank you for attending today's hearing. The panel is to issue in the near future a vetting report with regards to you as laid down in the law within 30 working days at the latest. But of course, we will do our best to deliver one as soon as possible, and we'll share that with you and the Superior Council of Prosecutor, the report that is. Thank you, and may you be successful in your work, and thus the hearing is closed.